What actions must a state court undertake in voluntary proceedings? In voluntary proceedings, the state court determines if a child is an Indian child or if there's a reason to believe and ensures verification steps, including contact with the child's tribe. Guidelines establish minimum requirements for determining a child's status, crucial for jurisdiction and law application, emphasizing accuracy through reason to believe, aligned with statute's language as reason to know. State courts must ensure placements for Indian children to adhere to regulations to both voluntary and involuntary proceedings, with judges considering parental requests for deviation from placement preferences, informing parents of options within family or tribal communities, including step-parent adoptions under the first preference as extended family members. This balances the interest of the parent with other interests protected by the Indian Child Welfare Act. How should a state court determine if there is reason to know the child is an Indian child? In voluntary proceedings, if a consenting parent requests anonymity, the court must keep relevant documents confidential. But this doesn't exempt them from verifying the child's status under ICWA. Additionally, the tribe must also maintain confidentiality upon receiving related information. When do the placement preferences apply? When a consenting parent requests anonymity in a voluntary proceeding, the court must give weight to the request in applying placement preferences. This does not mandate contacting extended family members to identify potential placements, but allows the tribe to identify placement preferences while protecting the parent's anonymity. How is consent obtained? A parent or Indian custodian's consent to a voluntary termination or parental rights or to foster care, pre-adoptive, or adoptive placement must be documented in writing and recorded by the court of competent jurisdiction. The court must explain to the parent or Indian custodian with a detailed explanation of the terms and consequences and withdrawal limitations. The court ensures comprehension in the parent's preferred language. Confidential request or anonymity may be protected through a closed session or written document. The consent prior to or within 10 days after an Indian child's birth is not valid. This process ensures individual consent validity and requires documentation before the court. What information must the consent document contain? The written consent for foster care placement must clearly outline any conditions, including detailed information about the Indian child, parents, name of the Indian child's tribe, tribal enrollment of parent and for the Indian child, or some other indication of the child's membership. In addition to the consenting parent or Indian custodian's name, address, and who arranged the placement of the prospective foster parents. States have the option to include more details beyond what is needed. The Bureau of Indian Affairs has a sample form for consent. A parent or Indian custodian may withdraw consent to voluntary foster placement at any time. To withdraw consent, the parent or Indian custodian must file a written document or otherwise testify in court. The court must ensure the Indian child is returned to the parent or Indian custodian as soon as practicable. A parent or Indian custodian may withdraw consent to a voluntary termination of parental rights at any time prior to the entry of a final decree of adoption. The withdrawal consent must be either by filing a written document or testifying with the court. The court must notify the person or entity who arranged any voluntary pre-adoptive or adoptive placement and ensure prompt return of the child. States may have additional withdrawal methods to protect parental rights and the child's welfare. The Bureau of Indian Affairs has a sample form for consent.